In this video, we're going to take a look at Brett Favre's response to Shannon Sharpe's motion to dismiss filed in Brett Favre's defamation lawsuit. Shannon Sharpe stated on the popular cable television show he co-hosts,
"You got to be a sorry mofo to steal from the lowest of the low." Skip, Brett Favre is taken from the underserved. He stole money from people that really needed that money.
Yep.
Those statements plainly are statements of purported fact, not opinion, no matter how many times Sharpe in his motion asserts otherwise. When it counted, when he made those statements, Sharpe never said he was merely expressing his opinion, nor did Sharpe take the opportunity to make that clear when Favre, before bringing this lawsuit, asked Sharpe to correct his statements. He does so only now because he is trying to avoid accountability for his maliciously false and defamatory statements. But Sharpe cannot escape accountability. His statements accusing Favre of crimes were false, and Mississippi law has long empowered private citizens to defend their good name. And then he goes on to write, Sharpe's excuse is that he relied upon media reports concerning a civil lawsuit by the Mississippi Department of Human Services, MDHS, against dozens of defendants, including Favre, to recover state funds that MDHS itself allegedly wrongfully transferred. Favre writes, none of those media reports said, and no one has claimed that Favre stole any money or committed any other crime. And then Favre goes on to point out that criminal charges were brought against John Davis and Nancy New, but not against Favre himself, who did not steal and has not been charged with stealing any money from anyone. And then we get down to Favre's second argument here, where he's saying the First Amendment, yes, of course, it does protect free speech, but it doesn't create a blanket exemption for any kind of speech that is defamatory. Just because you want to label it an opinion, that doesn't make it so necessarily. And then moving on to Favre's third argument in response to Sharpe's motion to dismiss, says Sharpe also claims that his statements are protected because he or others on the program disclosed the purported factual basis for his purported opinion. Maybe a little bit overuse of the word purported there. In fact, I hate that word, and I think it should be eliminated from all legal writing. But there is no such protection, whereas here, the speaker's disclosure of the factual premise was either incorrect or incomplete, or the speaker's assessment of them was erroneous. Here, Sharpe omitted key facts, including, among other things, that while others were charged, Favre was not, and that there was no allegation that Favre knew that the funds at issue were welfare funds. And then moving on to argument number 4, Favre writes, Sharpe also cannot rely on the excuse that his statements were mere hyperbole. This case is a far cry from the cases Sharpe cites where the allegedly defamatory statements using words such as blackmail or traitor were held not actionable because in context they were not accusations of crimes. The Supreme Court in Milkovich made clear that for an accusation to be protected as loose, figurative, or hyperbolic, the context must negate the impression that the speaker was seriously maintaining that the accused person committed the crime. Here, there was no such context. Sharpe did not negate any such impression. He only created that impression. And so there you have it, a summary of Favre's main defenses here in his response. There were a few highlights in the factual section of Favre's response that I wanted to point out to you. Here on page 11, he is saying that to date, we have seen no records indicating Mr. Favre knew that the Needy Family Funds was a program that served as the source of the money that he was paid. So in other words, he's putting the burden on Sharpe to come forward with any evidence whatsoever that he had knowledge of that. He's saying, if you have some sort of evidence showing that I knew that that was welfare money that was going to my daughter's volleyball gym, then come forward with it, put your cards on the table and prove it. But Favre here will ultimately bear the burden of proof in his civil case for defamation. He's going to have to prove that what Sharpe said was false, as opposed to Sharpe proving that what Favre did was true. Favre does go on to point out here, though, that Favre repaid the state $500,000 in May 2020 and the remaining $600,000 in October 2021. And then MDHS responded by filing an amended complaint that abandoned all claims relating to those funds. And then on the next page, Favre goes on to say he did not know that the funds at issue were meant for needy families. So Favre right here explicitly denies that he had any knowledge that the funds at issue were meant for needy families' welfare funds. As at no point does the Mississippi Today article or MDHS lawsuit accuse Favre of stealing. Since its inception in September 2016, Sharpe's Undisputed has become one of Fox Sports 1's or FS1 most popular shows, building a loyal following of hundreds of thousands of daily viewers. I will say it is one of my favorite sports shows, if not the favorite. Video clips of Undisputed are also posted on YouTube and routinely receive tens of thousands of views. Clips from this episode of Undisputed, repeating Sharpe's malicious and defamatory statements, were posted to YouTube and received over 1 million views, far greater than the show's clips normally receive. And so here we get into the meat and potatoes of Favre's legal arguments. His first main argument is that Sharpe's statements were, in fact, assertions of fact, not rhetorical hyperbole. Favre is pointing out here that the statements that Sharpe made were assertions of fact that can be proven true or false. Either Favre took money or stole from poor people, or he did not. He says Sharpe's statements are also not protected rhetorical hyperbole, as he claims. Here, both Sharpe's statements and general tenor of the segment on his show did not negate the impression that Favre committed the crime of larceny. It created that impression. And this was an interesting case that is very recent from the Western District of Texas, March 1st, 2023, where the court held that statements that plaintiff organized the January 6th Capitol riot and insurrection are not protected speech because they refer to provable and specific facts and events and are not opinion or rhetorical hyperbole. So apparently in this case, somebody sued somebody else for defamation. It looks like Bostic must have sued Daily LLC for accusing him of organizing the January 6th Capitol riot and insurrection, when in fact, maybe that was not the case. And then here, Favre is citing this case, Mullen, where the court held that a statement that the plaintiff abused drugs was not rhetorical hyperbole and is actionable because it can be shown to be true or false. He goes on to write that similarly, words that Sharpe used, for example, stole, can be rhetorical in some circumstances. If Sharpe had accused an athlete who signed a lucrative contract with a team of stealing from that team, no reasonable listener could believe that Sharpe was accusing the player of actually committing a crime. But here, when Sharpe stated that Favre is, for example, stealing from the lowest of the low, the context was Favre's purported connection to Mississippi's welfare scandal, and there could be only one interpretation. Sharpe was claiming that Favre stole from poor people. Then we see Favre's second argument here that Sharpe's statements are not protected opinions on a disclosed factual premise. Sharpe all but concedes that his statements were defamatory, but claims that they were privileged because they were opinions based on disclosed and publicly reported information, including allegations in the MDHS litigation and other public press reports, all of which are extraneous to the pleading. Sharpe's argument is meritless, Favre writes, because the factual basis underlying his purported opinion was incorrect and incomplete. The segment began with the show's moderator summarizing an article by stating that, quote,
yesterday, an investigation by Mississippi Today found that Brett Favre, along with the help of a former Mississippi governor, obtained welfare funds to help build a new volleyball center at the University of Southern Mississippi.
This summary in no way suggests that Favre stole from anyone or that he did anything nefarious. Nevertheless, seconds later, and without providing his audience any further factual basis, Sharpe began making the defamatory statements at issue, stating that Favre, quote,
you got to be a sorry mofo to steal from the lowest of the low,
and that Brett Favre is
taken from the underserved.
Favre counters that he never obtained welfare funds to help build the Southern Miss volleyball facility. In fact, while the Mississippi Today article published a denial from Favre's then attorney that Favre knew the funds he received were welfare funds, Sharpe's audience was not advised of this. As to the MDHS litigation, it is also false that MDHS sued Favre to recover unpaid interest, as that was not a part of its claims. Sharpe also falsely stated that Favre...
They're paying you to give speeches, and you didn't even give the speeches, and now you won't even pay the money back.
When Favre had already repaid the funds nearly a year before Sharpe's statements, as widely reported at the time. Sharpe further falsely stated that, quote,
you see what Brett Favre did for his alma mater? No, he didn't get no money came out his pocket.
This is also untrue. Favre and his wife have given millions of dollars to Southern Miss, including in connection with the volleyball facility. Sharpe's co-host claimed that Favre was...
The Mississippi Department of Human Services had to file a civil lawsuit against Brett Favre because he had not paid back the interest he owed on the 1.1 million that he was fraudulently given for giving no speeches.
A reference to the allegation in the MDHS litigation that Favre did not perform services for the money he received, which is also untrue. That's interesting. That's the first time I recall seeing Favre explicitly deny that he was given money for services that he didn't perform. That Sharpe was in the midst of a spirited discussion on a cable sports debate show, his own personal soapbox, does not give him a license to defame. And then in Favre's third argument here, he states that Sharpe's statements are not privileged reports of an official proceeding. And he says there is no official report or proceeding setting forth that Favre stole from anyone. And then finally, Favre addresses Sharpe's allegation that he did not give him sufficient notice under the notice of defamation claim statute. That Sharpe claims that the complaint should be dismissed because he presumes that this Mississippi statute applies to him and that Favre did not wait the requisite 10 days after sending a retraction letter to commence this lawsuit. This argument is meritless because this statute is inapplicable. Section 95-151 states, before any civil action is brought for publication against any radio or television station domiciled in this state, that would be Mississippi, the plaintiff shall, at least 10 days before instituting any such action, serve notice on the defendant. Neither Sharpe, his show, nor the cable channel his show appears on is a radio or television station domiciled in this state of Mississippi, and he does not claim otherwise. Thus, by the plain language of the statute, Section 95 is inapplicable to Sharpe. And that just basically destroys the no notice argument here. I didn't think that was a particularly strong argument anyways. So here are my final thoughts on this motion to dismiss. I thought that both the motion and the response were very well written, very persuasive. Ultimately, it's a close call, and I'm not sure either way. But if I had to guess, I would say that the judge denies Sharpe's motion to dismiss and allows the case to go forward into discovery. The statements did have more of a factual nature to them. Sharpe, if you watch the segment where he makes these statements, he says these with true animus towards Favre. You could tell he does not like Favre. This has the aroma of a factual dispute and not one that could be cleanly dismissed. Judges are generally reluctant to grant a motion to dismiss a case, especially one like this that's very fact intensive and requires really a look into the intent of the person speaking the statement and whether they harbored actual malice, how the audience perceived that statement. Those are all very fact intensive issues and not easily and cleanly resolved in a motion to dismiss. The First Amendment arguments that Sharpe is making here, they could go either way. They're persuasive. The hyperbolic rhetoric argument, that's persuasive, but ultimately, I think the judge will err on the side of allowing this case to go forward into discovery and allowing Favre to at least try to present his case on the merits of the case at the summary judgment stage. Now, that's not to say this case will go to trial, because in a federal lawsuit, almost always the defendant in a case will file what's called a motion for summary judgment after discovery is complete and take all of the evidence that they have to support their defense to negate the elements of Favre's defamation claim, and they'll present that to the court in a motion form. And the only way that Favre can survive that and proceed to trial is by showing that there are genuine disputes of material fact on key elements of his case. And so that is the biggest hurdle if Favre is able to clear this motion to dismiss hurdle. With that being said, if you don't want to miss any of the developments in this lawsuit, make sure to hit that subscribe button below and turn the bell notification icon on. And of course, as always, thanks for watching.